time.
Thanks.
All rise. Superior Court of Cobb County is now in session with the Honorable Judge A. Greg Poole presiding.
I'll have a seat. Get back.
Morning, Judge.
Court will call for consideration that matter concerning the state of Georgia versus Mahendra Patel. This is 25 CR 01090, and to have the defendant nearly in the courtroom.
Is it on? Thanks.
Record can reflect that the defendant is now in the courtroom. Let me just put on the record, since we're allowing some people to witness this via Zoom, my name is Judge Greg Poole. I'm in courtroom 6400 of the Cobb County Superior Courthouse. This is an open courtroom. The doors are open to the public. They're free to come and go as they please. And we don't expect anyone to be testifying via Zoom. I've just allowed certain people to witness via Zoom. And with that, who's representing the state?
I will be today, Your Honor.
Mr. Evans?
Yes, sir.
Thank you, Jesse. And we're here for the motion for bond. And I just let everybody know I have an incredibly busy day. This isn't my only case, and I slid it in at 11:30 just as a courtesy, basically. So I know there's a stack of other motions. Do we anticipate needing anything other than the motion for bond?
No, Judge. Well, when we had asked the court about that as well, and nothing. It was our interpretation that nothing else would be heard today. I talked to the state about one issue regarding a protective order, and I can address that in my argument for bond as well.
Okay. Well, having said that, I'm ready, Ms. Merchant.
Great. Thank you so much, Judge. And Judge, thank you for letting some people in support appear by Zoom. Also, the jury assembly room has been opened for other supporters. We have right now about 150 people down there, and they're still pouring in.
Made sure that was open for you.
Thank you so much. We appreciate that. Judge, we are here because the state has accused Mahendra Patel, and he goes by Mick, but Mick Patel, of, at first it was kidnapping, and then it moved to attempted kidnapping. So he was arrested on March 21st of 2025 for an incident that allegedly happened at a local Walmart on March 18th. The officer took out a warrant for kidnapping, not attempted, assault, and battery. Subsequently, the state indicted that case on April 3rd. We had a bond and probable cause hearing scheduled for April 16th, but when the state indicted it, they indicted it for attempted kidnapping and then misdemeanor assault and misdemeanor bond. So we were not able to have that bond hearing. Mr. Patel was not given bond at first appearance. At that time, he was charged with kidnapping of a minor. The state essentially is alleging that Mr. Patel had an interaction with a lady named Caroline Miller at this local Walmart. They've said that Ms. Miller was pointing out to Mr. Patel where the Tylenol was in the store, and that Mr. Patel grabbed the child and started pulling the child away from Ms. Miller. Ms. Miller has said that they engaged in a back and forth and a tug of war, as she described it, for 10 seconds before she was able to finally get the child back. Luckily, we have video. The video shows that Mr. Patel did lean in to Ms. Miller and her child. They were in a handicap scooter, mobility cart. There's different names. She is admittedly not handicapped, has admitted to that publicly, and was riding it because her child enjoyed it, sort of like a joyride. He interacted with her. We'll show you the entire interaction, but the relevant, super relevant portion is less than 5 seconds. Before he actually,
Less than 5 seconds?
Less than 5 seconds.
Okay.
And I'll walk you through that. It's about a 5-minute clip, and I'll walk you through that in a moment. But we're very lucky that we have that. So Ms. Miller pointed to where the Tylenol was. Mr. Patel went, got the Tylenol, and the video couldn't be clearer. Mr. Patel did not try to kidnap this child. What it shows, just to walk you through the timeline, because I think it's important, it shows starting at 8:17, you can see Mr. Patel entering the Walmart. And I'm going to show you parts of this, not all of it, but, and if you want to see more of it, we can show you all you want, but what we've done is pull out the relevant parts. So he enters the Walmart at 8:17, then at 8:18, you can see him enter the pharmacy area, and then you can see at 8:19, he's looking for the Tylenol. So, and at the same time, he had his cell phone, and he was actually texting his daughter, who's here, because he cares for his 86-year-old mother, who has osteoarthritis and requires a special kind of Tylenol. So it was this rapid-release gel Tylenol. He was trying to find it, and the daughter who was helping him, the daughter who also has cared for the mother, was actually sent him a picture. So we've actually asked for the cell phone to be returned because we wanted that evidence, but the state, when we asked for it to be returned, they took out a search warrant for it, so it's still in their custody. But we've seen those, and so we know that he was texting about this Tylenol. The first interaction that he has with Miss Miller is at 8:21, and that's the first time you see them. She's in this scooter. He's got his hands in his pockets. This is what I'll call the first interaction. Then you see her sort of puttering along in the mobility cart, and you see her sort of clip the corner. There's an end cap display case. Sort of clip the corner of that end cap display case, stop, and at 8:21 and 45 seconds is when you see Mr. Patel lean in. And what we've talked to the witnesses and how it's sort of been described by a lay witness was like a father, like the child's reaching for Mr. Patel like a dad, like if you walk up to a baby and they reach for you. And Mr. Patel leans in and reaches for the child like a father would, is how it was described. Mr. Patel offered to hold the baby while she got up to show him where the Tylenol was, to point, because she's trying to point at that time. And he believes fully that she's handicapped, and she's got 2 young children. One is actually at her feet. So it's this mobility cart with the basket that you're supposed to put groceries in, and then one child's actually at her feet, and the one's sitting on her lap. Thinks that she needs help. He's been described by many people as a very friendly older gentleman. Leans in. You can see this, you'll see this, leans towards him. Miller leans back. He immediately backs up, puts his hands back in his pocket. You see him back away at 8:21 and 51 seconds, put his hands back in his pocket, and she actually continues to stand up, point out where the Tylenol is, and he continues to walk towards the Tylenol. At 8:21 and 57 seconds, you see him leave and go to the Tylenol. Then less than 5 seconds later, you see Miss Miller back up. She actually backs into the display case at this point. The display case visibly moves. Then you see her run over her child's foot. Her child actually does fall out of the cart. She runs over the child's foot, and another bystander who's there, who had witnessed the other interaction with Mr. Patel earlier, he had been right there within arm's reach. The gentleman who described it as like a father, interaction. That gentleman jumps in and grabs the child because the child's foot is sort of under the mobility cart. At this point, that gentleman, and his name is Mr. Leyva, he's on the warrant, so that's public record. His name is Mr. Leyva. So he is talking with Miss Miller at that point, and then you see Mr. Patel sort of have a brief interaction with them as he's walking to get another employee. So this is the second interaction, but the first interaction after this alleged kidnapping. Mr. Patel then goes and finds a Walmart employee, and this is at 8:23 and 09. The employee comes back and takes him to find the Tylenol. Miss Miller's creeping along, and Mr. Patel and Miss Miller Mr. Patel and this Walmart employee walk past Miss Miller in the mobility cart. She says nothing. Mr. Patel goes, gets the Tylenol with this employee. So this is the third interaction. He finds the Tylenol. He leaves the pharmacy area. And at 8:25 and 19 seconds, the fourth interaction with Miss Miller, he walks past her and he shows her the Tylenol. Like, hey, look, I got what I was looking for. Like everybody had been helping him. Nobody could find this Tylenol. He shows it to her and she gives him a thumbs up. Then you see at 8:27, Miss Miller is talking with that same Walmart employee. At the same time, you see Mr. Patel waiting in line to pay for the Tylenol. He pays with his debit card. He gets it in a bag, he walks towards the exit, and then you see him for about 30 seconds talking with a Walmart employee, the people that check your receipts at the end, joking, talking with that employee, taps him on the shoulder. You can see he is friendly with everybody. Talking with all the employees, things like that. He's a very friendly gentleman, you can see that. The entire interaction that Mr. Patel was in Walmart was 11 minutes. He interacted with Ms. Miller 3 times after she claims that he snatched her baby. There were lots of employees around, lots of people around for all of these interactions. Nobody stopped, nobody says anything. There was a gentleman within arm's reach. Nothing. Nobody screams. Ms. Miller waited 5 full minutes to actually tell a Walmart employee. The employee had to try to convince her to call the police. We've interviewed this employee, said it was very surprising, didn't know why she didn't want to call the police. She just wanted to report it to Walmart. She waited a full 30 minutes to actually call the police. She was outside with her father and called and said, hey, I'm sorry it took me so long to call you, but I got my baby back. Mr. Patel didn't flee. Mr. Patel was in for a while after this alleged interaction. He was in Walmart for almost 10 minutes after this alleged interaction, still looking for the Tylenol. He talked to at least 3 employees after this alleged interaction. So during this time that the police have said that he fled, he remained in Walmart for a full 8 minutes. He talked to 3 different employees, and he passed Miss Miller 3 times. He used his debit card, and then he waited at the door and talked to an employee for over 30 seconds. I'm going to show you if you want to pull up. So what we've done is we have a couple different videos. One of them, because nobody wants to watch 20 different surveillance videos, one of them shows Mr. Patel coming in, and if you want to go ahead and start playing that. And then I can show you the exact interaction.
Judge, if I could be heard, this isn't a trial, it's a bond hearing, and so I would encourage the court to consider the legal bond considerations. I'm not sure that this is pertinent to that. If they want to submit this for the court's review, if they believe that they can articulate why it's pertinent to the issue of bond, which is the narrow issue we have today, I can understand that, and we can have that discussion. But if we're just playing videos to try the case in a bond hearing, the state would object to that. It's not relevant.
You have a relevancy objection.
Judge, I can't imagine anything that's more relevant than a video of the alleged incident. If you were trying to determine bond and you had a video of what the accused is accused of doing, that could potentially be the most relevant information you would ever have in a bond hearing, whether or not someone actually did what they're accused of. And the other thing is the state has alleged that he had flight, that he fled. That's been alleged from the beginning by the police. There's no, part of the bond factor is significant risk of fleeing or failure to appear in court. No. Is he a danger or a threat to anybody? You need to watch the video. He's not. He's clearly not. Is he at risk of committing any future felonies? No. I mean, I think it's highly relevant, and I would imagine the court would want to see this.
Well, I'll overrule the objection. As I read the pleadings, I looked at it as possible evidence that he would come to court, that he is not a flight risk. Of course, I haven't seen the video, right? So I don't know what it's going to show me, but I'll let you do that. And just so everybody knows, I have my own monitor down here. I'm not staring at the floor. So
wonderful.
I'll let you do that.
Thank you so much. All right, and this is the compilation. So the reason that we did this part is to kind of show the timeline. You can go ahead and play it. The timeline for the court when Mr. Patel enters the store at 8:16. And then you can see him walking, and he's on his phone, texting his daughter, which can be corroborated by the phone when we get it. Now you see him, he's walking to the pharmacy section. This is the pharmacy section. And now this is when he actually interacts for the first time with Miss Miller. So that's Miss Miller in the cart, in the scooter. The first time that they've met, and they're talking about the Tylenol. And so the gentleman, you can see a gentleman in an orange shirt behind them. That's the gentleman I was talking about. That's the witness. His name is Mr. Leyva.
All right.
He's the one that later assists.
All right.
And witnessed the whole thing. So this is the other view, so you can see how close Mr. Leyva is. And behind this display cart is that's when you can see the beginning of Miss Miller's cart. So the incident, the alleged incident, is happening now. Here's the other view of it, flipping back so you can see both views. That's the alleged incident right there. Then she points. He moves on, goes to get the Tylenol. She backs up into the display cart. She's laughing, joking with this gentleman. This is literally a split second after this alleged kidnapping. You see her child kind of get off the cart. She runs over the child's foot. The guy jumps in to help. She was having trouble with the cart. I mean, everybody says that. All of this is after this alleged kidnapping has taken place. There's Mr. Patel entering the video again. You see him walking past. He talks with this guy that's witnessed this alleged kidnapping. Miss Miller's right there, doesn't say a word. She's puttering along in her cart. He's chatting with this gentleman, asking about the Tylenol. This gentleman speaks Spanish, so the communication's a little bit difficult there. Mr. Patel goes to try and find a Walmart employee. He walks past Miss Miller again. There's that other interaction I mentioned, the third interaction, walks past her to find a Walmart employee. Again, this is all after this alleged kidnapping, so, he's not fleeing. Going to find another employee. There's the employee walking him back to the Walmart pharmacy to show him where the Tylenol is. So you can see Miss Miller puttering along in her cart in the back of this video. This employee shows Mr. Patel where the Tylenol is. Miss Miller puttering along still on her cart. Mr. Patel walks past her, shows her, look, I got the Tylenol. She gives him a thumbs up. He keeps going. That's when, at 8:27, that's when she first told this Walmart employee about this. At the same exact time, Mr. Patel is paying for his Tylenol, so he's still in the store. And you can see if you zoom in, and we didn't do that, but it's the rapid release Tylenol. It's a special gel Tylenol that it's the exact same label that his daughter texted him a picture of to buy. And Mr. Patel has no medical background. It's not surprising that he's asking his family for help. His wife's a doctor. His daughter's in medical school. So, I mean, it's not surprising he's asking for assistance with this. Pays with his card in his name, linked to his bank account. Him talking with this employee on the way out. Complete opposite of fleeing. I mean, he's like the typical elderly gentleman who talks to everybody at the store. And then he leaves. 8:28, 8:29, he leaves. And Judge, so I've got the two videos of that alleged interaction if you want to see them. I don't want anybody to think anything's been taken out of anything, or, I mean, it's all on here, but what we did with this compilation is try to show both sides, you know, back and forth. I don't want to take up the court's time needlessly, but we have those. We're ready to show them. Happy to show them if you'd like to see them. I don't know what the court, would you like to see the other, just those interactions?
I don't know that I need to.
Okay.
If you think it's important, I will.
No, I don't think it's important. All right, Judge. So moving on. So the other things that the evidence in this case, there's two alleged witnesses, the Walmart employee and Mr. Leyva. Mr. Leyva is mentioned on the warrant. Both of them, we've interviewed them. Both of them had said if they'd seen a kidnapping, an assault, an attempt, anything like that, they would have stepped in, that they were there, didn't see it. They all confirmed the Walmart was busy. There were lots of people around. The Walmart employee said that Mr. Patel was a friendly older gentleman, was very friendly with her, kind of gave her like a hug almost, like she was so happy when she finally helped him find the Tylenol. She said that she didn't know what was going on with Miss Miller, but she's not permitted to ask what her handicap is, but she said it was suspicious that she didn't scream, call 911, anything like that. And then Mr. Leyva, the gentleman in the orange shirt that you saw, again, he said that Mr. Patel lifted the child like the child's father, and that Miss Miller sort of pulled back the child. There was no tug of war. Mr. Leyva actually was mistaken and thought it was the younger child that all this was happening with. He was kind of confused, but the one thing he was sure about was that there was no attempted abduction, and had he seen anything like that, he was close enough that he would have stepped in and done something. He also told us that there were lots of people that witnessed the interaction. He speaks Spanish, so we had a Spanish interpreter interview him because there was definitely a language barrier with him, though. Mr. Patel talked to the police. He answered the police's questions. He told the police that he leaned in to pick the child up so that she could show him where the Tylenol is. He told them that.
Where was this?
At the police station when he was arrested. So he was arrested on March 21st. So before, they didn't talk to Mr. Patel. The police got the warrant for kidnapping. They arrested Mr. Patel on March 21st. They took him to the police department and interviewed him. When they interviewed him, and the state has not provided us a copy of this, but this is based on pleadings and Mr. Patel, what transpired there. He said that he did. I mean, he confirmed that he leaned in to pick the child up. so that she could stand up and show him where the Tylenol was. At that point, he believes, as anyone would, that she's handicapped. And she's got 2 young children, which you can clearly see she's having some trouble with the cart. It's a reasonable thing. And if you think that there's a child that's falling or might fall and someone's trying to stand up to help you, the reasonable thing would be to help that person. The state in one of their pleadings pointed out that he did not tell the police specifically that he thought the child was falling, but nobody asked him that either. He also said that they didn't ask him if he told Miller immediately that he was trying to help her. But what he explained was that Miller didn't want his help. As soon as he realized that, he stopped, put his hands back in his pocket, and moved on. So we're talking a few seconds here, and he's trying to help. She says she doesn't want his help. He pulls back. You can see it, and you can see it on the video. And we know Mr. Patel cares for his 86-year-old elderly mother. We know why he's there. He's not there for a sinister purpose. Judge, I anticipate the state's probably going to focus a lot on Mr. Patel and his prior record. Mr. Patel has a conviction from a 2006 conspiracy. It's a Class E felony for those that don't really practice in federal court, myself included. I had to call the federal defender to explain how it all works to me. A Class E felony is sort of like our high and aggravated misdemeanor. It's a 1 to 5 type of offense. It's a conspiracy. He accepted responsibility for his role in a 2006. It was a white collar case. It's a conspiracy, and the allegations, I was able to get the transcript and get the indictment and get the plea recommendation and all of that. Mr. Patel and another gentleman who was one of his neighbors, Mr. Obleton, they essentially contacted a company and they were asking for rewards to get a contract for a school, public school system's IT system. So at the time, Mr. Patel was an engineer. And he entered into a sales agreement in early 2007, whereby he would get a 3.9% commission for if this company got the sales agreement, the IT agreement, to do the IT stuff for the school system. In March of 2008, he did receive a sales commission for this. And so those are the 3 overt acts for his role in the conspiracy. I wanted to make sure I knew that so that I could explain, the depth of it, because I assumed it would be a big deal to the state. Everything else was contributed to Mr. Obleton, but Mr. Patel helped the government convict Mr. Obleton. In exchange for that, he was granted leniency. He pled to the Class E felony. It's considered the least serious of all federal crimes. He paid all of the money back, not just the money that he gained. He actually paid Mr. Obleton's money back also, and the case was terminated early. So we would actually submit that that shows that he is in compliance with court orders and helps with bond, because not only did he pay what he owed, but he paid what Mr. Obleton owed the government back. He reimbursed them in due course early, and his probation was early terminated. He has another case from 2020, a reckless driving conviction. In that case, he accepted responsibility for the reckless driving. He completed all of the conditions that the court asked him, and he actually did such a good job and did it so early that his probation was early terminated after just 6 months. He has a pending 2005 DUI less safe. It's a non-test case. It is, he was arrested, and I was able to pull the reports. He was arrested, and the probable cause was the odor of alcoholic beverages emanating from his breath and his bloodshot eyes. He was arrested, and he was released on bond. He is currently on that bond, and I'm not sure if the state will make a big deal out of that or not. Ms. Miller has a conviction for DUI. Mr. Patel does not. But again, he complied with that court order, early terminated, did a great job. I want to talk a little bit about one thing I just want to point out before moving on, because I think it'll save us some time. The state had mentioned to us that they wanted some type of a protective order for the discovery. We've not been able to get discovery in this case. The case was indicted April 3rd. We opted in on April 7th. We have asked repeatedly to get the state's file. Mr. Merchant tried yesterday. He was supposed to go and review the open file, was denied access to that. They said they're copying it, so we should be getting it, but one of the issues was they want to make sure that we don't disseminate any witness information. We have not disseminated witness information, and we will not be disseminating witness information, although that information is already out in the news. And it's not surprising. There's quite a bit that's that's out there, that's public. Ms. Miller did quite a few press conferences early on in the case, press interviews, and obviously we have done that in response, but her information's out there. There's a lot of public police reports involving her that has her address. And so we are certainly not providing that to anybody. We will agree not to provide it to anybody. We already have it and haven't provided it to anybody. But I know the state's concern was over witness information. We haven't released it. We wouldn't release it, but it's really not hard to find. There's over 20 police reports in the last 7 years involving Ms. Miller. It's not hard to find this
I
information.
don't know how that's relevant to the bond motion that we have today, Judge, so I would object to that.
It's relevant to the protective order. And I'm sorry, I was deviating for a moment just on the protective order, but I can save that and argue that separately.
All right.
Okay. So as far as bond, the last thing I wanted to point out to the court is my client's ties to the community. Judge, my client, he's got friends. He actually has friends here that he grew up with and went to high school with in India that have flown in for this bond hearing. They're here in this courtroom. We have over 100 people in court. We have over 150 downstairs. There's a lot more online. He's married. When he first came to this country, he went to school in Ohio. He got his master's in electrical engineering. His wife went to medical school in Ohio. They both graduated from Cleveland State, and they've been married for 31 years. They had their first daughter when they still lived in Ohio. They moved here. They have lived here in the Harrison High School District for 21 years. They own their home in West Cobb. They were zoned for Harrison, but both of his daughters went to the magnet school at Kennesaw Mountain. They both got full scholarships and graduated from Georgia Tech. They're both in graduate school currently. One is in medical school and one is in MBA school. He and his wife are now retired. They own property and they manage that property. Quite a bit of property. He's the caregiver for his 86-year-old mother that lives with him. His wife is here. One of his daughters is here, the one who's in MBA school. The daughter that's in medical school was in the middle of finals and it's available on the Zoom. He is very active in his community, as I'm sure the court can recognize by the outpouring of people that are here to support him. He is active in the Kiwanis Club. He's a board member, the Lost Mountain Kiwanis Club. He is active at Read Across America and a program called Terrific Kid Program, where they actually go and read to children at North Cobb High School, children in need, children who have developmental disabilities, at Mount Perrin, and also at Due West Elementary. He's active at his temple in Cartersville, the Shareem Temple, and there's members of that community here in support as well. He has, at this point, before, as of 9 a.m. this morning, 46,000 signatures on a petition supporting his release. There's been letters written in support of his release from the South Asian Bar Association, the Cobb County Democrats, the Cobb County Republicans, the Hindu American Foundation, local medical providers, and I could go on and on. I honestly can't keep up with all the people that have reached out in support. He has members of his family here, his wife, his daughter, uncles, aunts, cousins, friends, schoolmates, members of the community, his neighbors. His neighbors have contacted us multiple times and just can't believe that he's in jail. His house is the house where the bus stop is, and all the kids like to wait for the bus at his house. And so he's got neighbors here in support of him, just a lot of community support. So, Judge, we would ask that you release him on bond.
How old is he?
How old are you?
57 years.
57. I was going to say 56. I forgot. He had a birthday 2 weeks ago in the Cobb County Jail. So he is now 57 years old. He's been in the Cobb County Jail for 6 weeks without a bond. And we would just ask that you release him on bond, Judge. And if there's anything else you want to know about him.
In what amount?
$10,000, please. Thank you.
Thank you. Mr. Evans?
Yes, Your Honor, thank you. I always think it good to make a record about the legal standard for these type of issues, so I want to do that first. I know the court's well aware of it. Nonetheless, we do need to make a record. The burden of proof is on the defendant for when it comes to bond issues. That's Dunn versus Edwards, common spelling for both of those, 275 Georgia 458. The defendant must prove evidence as to each of the four Aiella factors. We haven't really heard about those four factors, so I'll give them to you now, Your Honor. I know you're aware of them. They're also codified statutorily in 17-16-1. They must prove that defendant poses no risk of flight, no significant danger to person, community, or property. The defendant poses no significant risk of committing a new crime, poses no significant risk of intimidating witnesses or obstructing justice. Of note, failure on any one of those factors would authorize the court to deny bond in this case. I will point out a case out of Cobb County, Constantino versus Warren, Constantino, 285 Georgia 851. Defendant is not entitled to bond as a matter of right on felony offenses that are under 90 days before indictment. In this case was indicted within that 90-day period to alleviate any concerns about the bond. So I say all that to say to the court that defendant is not entitled to bond as a matter of right. As we sit here today, it's entirely discretionary for the court whether or not to grant a bond. And that is where we stand, is that it is within the court's discretion to grant a bond, but you are absolutely not required to grant a bond because we have moved expeditiously to make sure that the defendant was afforded his opportunity in court by indicting him in a timely fashion. I will note that the initial warrant was in the no bond stages, so there's been some chatter, allegations about the state's role in that. It was not the state that had anything to do with the defendant's current no bond status. That was done at the magistrate court level by a magistrate judge that was passing on the sufficiency of the evidence in terms of looking at the warrant. I will tell the court, in reviewing this case legally under Garza and some of those things, we believe that kidnapping would be appropriate. Nonetheless, looking fully at the facts of this case, an attempted kidnapping certainly seems like a better charge, which is why we did have some urgency to get this case to the grand jury to make sure that we had the most accurate charge pleading in terms of the charging documents that we think is appropriate. Slight asportation is what's required for a kidnapping. I think the general public thinks about kidnapping, has this visual image of white vans snatching kids off the street, and the court knows, and state knows, the defense knows, legal experts know. That's not the legal definition of kidnapping. It's the slight asportation of a person against their will, and so the appropriate charge we deemed, and the grand jury agreed, is an attempted kidnapping. He's also charged with assault and battery as well for what happened. So you've heard a little bit about assertions of what defendant's connection is to the community and all of those kind of things in support of this. There's really not been a whole lot of testimony about the 4 IELA factors that I've articulated to the court. So I will tell you that the victim's mother is on this call. She's been in communication with the state. She's expressed to us her apprehension and trust in handling this case. She's been very deferential to the state. She is of the belief that defendant needs treatment. I too am of the belief that this defendant has got some serious issues, as we're about to talk about, and I want that to be a component of this discussion here. So because the defense has played one video, am I okay to sit down so I can use my laptop, Judge? Thank you. I want to show a zoomed in version of the clip. Yeah. And if you'll pay attention here, Judge. When you zoom in on it, you can actually see defendant grabbing this 2-year-old child, the child's 2 at the time, and tugging the child, attempting to tug the child away from the mom. I'm going to show you a still version in a second too that actually shows the child's legs hanging over the lap of his mother as the mom tries to pull her child back to her lap. You can see he's kind of in her space. I know there's a narrated, edited version that was presented, by the defense, and sure, the state would say if you don't take a closer look, it might cause concerns. But when you do take a closer look, you can see him tugging on this child, and there's the legs, before mom is able to regain control of her 2-year-old and bring the 2-year-old back to her lap. So here's the actual. You can see the legs of the child dangling as Mr. Patel tries to pull the child away. Listen, Judge, is this an unusual case? I would say it is. The state's not oblivious to the fact that this is a very bizarre set of circumstances. Nonetheless, this defendant reached down and grabbed a 2-year-old child from the lap of a woman in a Walmart at 8:30 at night and attempted to pull that child from her lap. The facts are not governed by the state here. The facts are governed by the choices of this particular defendant on this particular night, this particular public Walmart, as he encroached on the space of this mother and her two children. I will tell you that there was an employee that told the police that the defendant also touched her and that he said something like he loved her. There is some evidence of apparent intoxication on the defendant's part, and looking at his criminal history, it's not terribly surprising because it would appear that intoxication and alcohol issues have been legally an issue for him in the past as well. The victim's mother, for your knowledge, is 26 years old. She was 5'3". She has 2 children. She was minding her own business at a Walmart when this defendant, 56, a convicted felon who served time in federal prison, get to that in just a second, who's out on bond on a pending case, 5'10", 240 pounds, made the choice that he's going to reach down and grab her child and try to pull that child off her lap. He was unsuccessful in doing so, which is why an attempted kidnapping is perhaps a better charge than the initially charged kidnapping, even though you can clearly see the slight asportation as is contemplated by the law. So this defendant grabs a 2-year-old child sitting on his mother's lap, and despite the release of somewhat edited, narrated, scripted, when you look at the zoomed in view, you can actually see the corroboration of what the mother has told the police and told the Walmart employees as well. She actually told the police, and it's corroborated by the video evidence, that she pulled the victim back to me and that she refused to let go of her child. I do want to talk a little bit about defendant's statement because he made a number of admissions that we really haven't talked about in this case. So he was interviewed by the police. It was admittedly a couple of days later. So the police issued a bolo, a be on the lookout, the day of, trying to identify him. And it was only through looking at some flock camera video and some video surveillance that they were finally able to piece together who this individual was. So it happened on the 18th of March, and he wasn't arrested until the 21st in a neighboring jurisdiction before he was transported to the police for his interview. So we can call that whatever you want. He certainly didn't stay on the scene, but when you talk about his admissions, I think they're telling as to where his mindset is into what he had done prior to his arrest. So though those statements are somewhat self-serving, he admitted that he grabbed the child. He admitted that he upset the mom. To quote him, he said, "She thought I was going to take her kid." I said, "No, no, no." Then he said he saw her on the phone, and he pleaded with her. I said, "Please, I'm not going to take your kid," before heading out of the store. He said, "I was holding the kid. I realized she didn't want me to." He admitted that he realized she was afraid that I was taking her kid. Defendant Patel was confronted by the police and said, "You're a stranger to this child, Mr. Patel. Why are you touching this child?" And he admitted thereafter that he had scared the mom and nonetheless left the Walmart anyway. At the tail end of his interview, he said that he wanted to apologize to her for what he had done. So there are some admissions that really go towards kind of the consciousness of guilt in that short clip that was just played for the court that are somewhat, they corroborate what Mama said, that she was scared by a man that was trying to grab a 2-year-old child from her lap, and he admitted that his conduct had placed her in that apprehension as well. So, we do have safety concerns because of all the media that has been generated by this case, largely because of things, candidly, that the defense has put out, which is why we filed the motion for the protective order. Our preference is not to try these types of cases in the media, but instead to have full, fair, transparent court hearings to deal with these things. The fact of the matter is that this mother was with her 2 kids minding her own business, and this man, Mr. Patel, made a decision to grab a 2-year-old child from her lap at night in a Walmart. Even the witness who was interviewed by the police on the next aisle said that he was essentially unnerved by what he had seen and wanted to share that with the police as well. There are 2 separate 911 calls, one placed by the victim's mother, one by Walmart employee. Of course, you've now seen some of the video. I've told you about the Be on the Lookout that was issued the night of, as they tried to identify who this stranger was to this woman who tried to grab her kid from her lap. And fortunately, thanks to our advances in technology, I'm sure the court's aware of it, Flock, for our purpose of our record, as a license plate reader, we're able to identify the defendant and realize, well, this is a man with a criminal history who's out on bond for a DUI that's pending in state court, and that's what prompted police to be able to go locate him, pick him up, bring him in for the interview, where he made these admissions that I've articulated to the court about his conduct and about what he did. There is evidence to support that he probably was intoxicated at the time. The delay in getting to him, though...
I object. There's no evidence of that at all.
Sure. The description by witnesses suggests that there's something going on with him, that he may have been intoxicated, and certainly his criminal history, as I'm about to present that to the court, would show that there is a history of problems with alcohol use. Based on the Walmart witness and what the victim described, we certainly have reason to believe that he may have been intoxicated at the time. Of course, he didn't stay at the Walmart, so we weren't able to get a blood draw or anything like that. All right, so I do want to talk about criminal history.
You're going to give me something?
I'll show you now. And this is the motion in state court. Actually, I need that one because it's highlighted. You can have this one.
Is it the same thing?
Yeah, same thing. Thank you. So, Your Honor, I'm going to provide to the court a copy of the criminal history and then a motion filed in the state court regarding the pending case that's over there as well. What you'll see on the criminal history is that defendant is a convicted felon, convicted of conspiracy to defraud the United States. He was arrested for bribery as part of that arrest as well. That was not what he was convicted of, though. It was conspiracy to defraud the United States. And while assertions have been made about the level of this, I will point out that defendant did serve federal prison time. I have not run the criminal history of everyone in the courtroom, but I'm aware of only one person that served federal prison time as a convicted felon in the courtroom, and that would be Mr. Patel. He admittedly served 6 months in prison, received looks like a 42-month sentence. He was on probation for a number of years for this felony offense that he's been convicted of. He did have a DUI that he was convicted of, a lesser included offense, reckless, that's February 7th, 2022. Highlighted that for the court. I've pointed out the defendant has a third arrest now pending by Kennesaw Police Department. That was December 6th of 2024. So that case is actively in the pipeline at the time defendant commits this offense at the Walmart. There are conditions of that bond that are actually attached to the solicitor's motion to revoke that bond. So that's the other document that I've handed to the court, is a motion to revoke defendant's bond in state court based on this new arrest. If you look at those bond conditions from January 28th of 2025, among other things, shall not violate the laws, shall not drink alcohol or use drugs. And we've talked a little bit about that as part of the state's presentation of the case. So that was filed, the motion to revoke bond, I believe, April the 28th. So here, while the defendant was on bond, he committed a new crime on March the 18th. And fortunately, because of our ability to leverage Flock and technology, we're able to identify who this was, who this stranger was, who grabbed a 2-year-old child at night in a Walmart, and that led to his arrest and ultimately to his statement and admissions that he made on about March the 21st of 2025. So this is his fourth arrest. Okay, fourth arrest, Your Honor. The fourth being while he was already on bond on a pending case here in Cobb County, Georgia. And so legally, this court is not required to give a bond. The state's of the opinion he's not a good candidate for bond based on the history that we have here. I would suggest to the court that if you're inclined to grant a bond, even though you're not required to, that we be heard about some specific conditions of that bond. But it is concerning from the state's perspective that you have a man who's a convicted felon on his fourth arrest, one while on bond here in Cobb County, Georgia, who made admissions to his conduct here. And in light of that, we would suggest to the court, not a good candidate for bond at this point. We're open to having discussions with the defense about perhaps some reasonable resolution of the case when it's appropriate after going through the discovery process. But at this point, you're not required to give the court, to give the defendant a bond. And so we would urge the court to consider all of these things when you weigh your decision. And we would like to be heard if you exercise your discretion, say, well, I'm going to give a bond in this case for some reason, then we'd like to be heard on what conditions of that bond would be appropriate in light of the unique circumstances of this particular case.
Understood.
Thank you, Judge. Judge, I just want to respond to some of the specific things that the state brought up. They said this is his fourth arrest. We told you about all of the other ones. We told you about exactly what happened in those other cases. And the one thing that I really want to, really the two things that I want to talk about are the state's theory that this is an apparent intoxication, but they didn't tell you one single person who said they thought Mr. Patel was drunk or that they smelled alcohol, not one single person. They said it was because of his actions and his behavior. You saw the video. I mean, you saw the video. There were people talking to him. He talked to 4 different Walmart employees this close to him. I think maybe because he has a DUI that was dropped down to a reckless driving and a DUI arrest, maybe that's where they got this from, but there's absolutely no evidence of that here. None whatsoever. So I don't know what conditions they're talking about, but there's no evidence of that here at all. And there's plenty of people that they could have talked to about smelling an odor of alcohol or something like that, bloodshot eyes, whatever. The state did comment, though, on 2 things. They commented on my client's statement, which we have not seen, but what it sounds like is it corroborates exactly what I've told you, what Mr. Patel has told you, corroborates exactly, and that's why we filed a demurrer, because he can admit to these facts and still not be guilty of a crime. So that's why we filed a demurrer in this case that we think will ultimately be successful. But the other thing I wanted to just touch on, we have not seen any of the state's file. We were expecting something significant today, and there's nothing. The state got this GCIC on March 31st. This is the first we've ever seen it. Luckily, my clients told me about all of these, and I was able to investigate all of them. But we have been trying to get a consent bond since March 27th in this case. We have been trying to see and access the state's file, and they will not allow us to. This is, now all of a sudden throwing things out which we haven't been able to see. But the big issue is the state commented on Ms. Miller's credibility. They said that she's a young mother, 27, short, whatever, and that it's very reasonable for her to be scared. So because the state commented on her credibility, I wanted to just,
I would object. I don't think that that was a comment on credibility. Those were statistics about her age, height, weight, those types of things. So I don't agree with that recitation. I think that's facts not in evidence before the court in terms of the bond hearing.
Response.
Judge, the rules of evidence don't apply at bond hearing, first of all, and the state did comment on her credibility. They specifically talked about her being a young mother, and that it was reasonable for her to be scared in the situation of my client. They talked several times about how, his interaction with her and how he interacted with her should have scared her, so I think it's entirely relevant. They also mentioned that she's, as far as the bond factors, they mentioned something about, direct quote, something about being concerned if he gets out on bond. Oh, the mother is on call and expressed apprehension of my client. So I think it's relevant a little bit, just a little bit. I mean, trust me, I'm not going to go through all 20 reports, but a little bit relevant to talk about her alleged apprehension.
It might be relevant, but I don't believe it necessary.
Okay, great. Well then, thank you, Judge. So, Judge, I do think that we have satisfied the ILF factors. We have shown that he is not a threat to the community, not a flight risk. Look at all the people here. I mean, he's definitely not a flight risk. We've tried to show you that. He's got significant ties to the community, significant property in the community, and he's just not a risk. So we just ask that you grant him bond. Thank you, Judge.
Thank you. Well, first of all, let me just comment on the amount of media attention and internet attention, social media. It's always been part of my duty anytime I have a case similar to this that I do not watch local news. If I'm in the Marietta Daily Journal and I see anything that leads me to believe this might be my case, I don't read it. I don't look at anything on social media, but I must say that it's impossible to not see that it's out there, and it's been very difficult to not look at anything, but I've done my very best. So I feel like I'm going into this on an even keel with the state and the defense. I'm going to grant this man a bond. He's entitled to a bond based upon even the allegations of the state. His history here, he owns property, you said, in the Harrison district. He's educated, he's retired, manages properties, plural, apparently. He's married, he's in the Kiwanis Club. I mean, if he's got all that he needs to show me that he's a member of our community and that he has ties to the community. I don't blame the state from pointing out, and you did it yourself, Ms. Merchant, that he has some convictions. He doesn't have any type of conviction that bothers me in terms of any type of violent behavior or anything of that nature. I don't see any haven't heard any evidence of any arrests for any type of sexual, certainly child sexual type arrests. I'm not worried about that. I don't believe he poses a risk to the community. The evidence from the video, and I won't comment on what I think the video really shows as far as guilt or innocence. It's not my job today. But the facts do show me that he hung around, and I don't find that he's a flight risk based upon what I saw in the video and what was just, I'll receive it as a proffer from counsel about him hanging around. I'm not concerned that the police didn't get him the same day because he's presumed innocent, and innocent people don't worry about the police coming to get him. So that didn't bother me. I'll grant a $10,000 bond. That was the number you gave me.
Thank you, Judge.
I don't have any problem with it. He can make it any way he wants. It doesn't have to be a cash bond. As far as conditions, let me hear from you, Mr. Evans, as to any special conditions that, I mean, I would always put in there no drugs and alcohol, not because of the allegations that you've made, but That's every bond I do. And although I'm not a magistrate, I don't grant that many bonds because of reasons you know about. No drugs and alcohol, no contact with the alleged victim or any member of her family. What else do you want?
You've nailed almost all of them, Judge. No contact with the victim, the family, that Walmart in particular, I would say.
Don't
as well.
go to that Walmart.
Sure. Drug, alcohol evaluation, treatment, and screens. So
I don't have enough to make me do that.
Okay.
If you know, if he picks up another problem with alcohol, then he probably will be back where he is right now. I mean,
Sure.
so
and then the follow up to that, I think you've already articulated no alcohol or drugs that are not lawfully prescribed to him.
right.
Yes, sir.
Do you object to any of those conditions?
No, Judge, not at all. I'm not sure, this wasn't mentioned, but I just wanted to bring it up in advance. He has a trip in August that's already been paid for. We just want to make sure that he can go on that trip because it was a trip that was originally bought and paid for, and then his father died and it had to be moved. And it's with both of his children, extended family. It's an international trip. And so that is very significant to him
Well,
in August.
he's on probation right now?
No,
He's not on probation
He's not,
right
no.
now. You know, I got people in front of me that live in New York, and, you know, they certainly can go to New York.
Thank you.
And if I thought he was a risk, I wouldn't let him out of jail.
Thank you, Judge.
If you want me to put something in writing, then I'm happy to.
And I appreciate that. I don't think it'll be an issue with that. Thank you.
All right. Then why don't we do this? Madam Clerk, if you'll get the standard order, work with counsel, get both of them to look at it. Mr. Evans can consent as to form only, and then bring it back to me in chambers so that I can review it, and then I will come back in the courtroom and go over them and get the man's signature, and that'll take care of it. All right.
Thank you, Judge.
Thank you. We'll be in recess for a brief period.
He's going to have to sign this.
Yes, I think that's exactly. I know you got it.